Ang kakagiligo ko lang, guys. And I'm reading still article 228. The article 228, Roman numeral number 9-E, on labor cases involving entities immune from suit. Principle of immunity from suit as applied to labor cases. A. Immune entities cannot be sued for labor law violations. In this jurisdiction, the generally accepted principles of international law are recognized and adopted as part of the law of the land. Immunity of a state from suit is one of these universally recognized principles. Parem parem non habet imperium. Unequal has no power over unequal. Immunity is necessary to assure unimpeded performance of the functions of international organizations. The purpose is to shield the affairs of international organizations in accordance with international practice from political pressure or control by the host country to the prejudice of member states of the organization, and to ensure the unhampered performance of their functions. In the following cases, the immunity principle has been applied. Number 1, Department of Foreign Affairs versus NLRC, involving an illegal dismissal case filed against the Asian Development Bank, where it was ruled that this entity enjoys immunity from legal process of every form, and therefore the suit against it cannot prosper. And this immunity extends to its officers, who also enjoy immunity in respect of all acts performed by them in their official capacity. The charter and the headquarters agreement granting these immunities and privileges to the ADB are treaty covenants and commitments voluntarily assumed by the Philippine government, which must be respected. LASCO versus United Nations Revolving Fund for Natural Resources Exploration, UNRF and UNRFNRE, involving an illegal dismissal case filed against the respondent, which is a specialized agency of the United Nations. In dismissing the case, the High Court said that being a member of the United Nations and a party to the Convention on the Privileges and Immunities of the Specialized Agencies of the United Nations, the Philippine government adheres to the doctrine of immunity granted to the United Nations and its specialized agencies. Both treaties have the force and effect of law. USMAG Philippines versus NLRC, involving illegal dismissal of a Filipino employee of the Joint United States Military Assistance to the Republic of the Philippines. In upholding the labor arbitrator's dismissal of the case, the High Court enunciated that since the employment contract was entered into by JUSMAG in the discharge of its governmental functions, JUSMAG being an entity performing a governmental function on behalf of the United States government pursuant to the Military Assistance Agreement dated March 29, 1947, the illegal dismissal suit is one against the latter, albeit it was not pleaded in the complaint, considering that the United States has not waived or consented to the suit. The complaint against JUSMAG cannot prosper. JUSMAG is beyond the jurisdiction of Philippine courts. Larkins versus NLRC, involving the dismissal of workers who worked in the maintenance of dormitories in the former U.S. Clark Air Base in Pampanga. The Supreme Court, in dismissing the case, invoked, among other reasons, lack of jurisdiction in the light. Lack of jurisdiction. Lack of jurisdiction in the light of the fact that their suit was against the United States. Against the United States government, which by right of sovereign power operated and maintained the dormitories at Clark Air Base for members of the U.S. Air Force. Exception to the rule. There is an exception to the immunity rule as exemplified by the United States versus Honorable Rodriguez, where it was held that When the function of the foreign entity otherwise immune from suit partakes the nature of the proprietary activity, such as the restaurant services offered at John Hay Air Station are retaken by the United States government as a commercial activity for profit and not in its governmental capacity. The case for illegal dismissal filed by a Filipino cook working therein is well within the jurisdiction of Philippine courts. The reason is that by entering into the employment contract with the cook in the discharge of its proprietary function, it impliedly divested itself of its sovereign immunity from suit. Sovereign immunity from suit. The reason is that entering into the employment contract with the cook in the discharge of its proprietary functions. Discharge of its proprietary functions. Role on immunity of a foreign government being the principal of a local recruitment agency in OFW cases. Petitioner in ATCI Overseas Corporation versus Office of FINA. Rule on immunity of a foreign government being the principal of a local recruitment agency in OFW cases. Petitioner in ATCI Overseas Corporation versus Josefina Etching, a private recruitment agency which deployed respondent as a medical technologist to its principal, Ministry of Public Health of Kuwait Ministry. Later, dismissed before the expiration of her 2-year contract of employment, she filed an illegal dismissal case before the labor arbiter. One of the defenses set up by petitioner is that its foreign principal is a government agency clothed with immunity from suit, or that such foreign principal's liability must first be established before it as agent and be held jointly and solidarily liable. In debunking this contention of petitioner, the High Court ruled that the imposition of the joint and solidary liability of private recruitment agencies with their foreign principals under RA number 8042 is in line with the policy of the state to protect and alleviate the plight to working class. Verily, to allow petitioners to simply invoke the immunity from suit of its foreign principal or to wait for the judicial determination of the foreign principal's liability before petitioner can be held liable renders the law on joint and solidary liability inutile. RA number 8042 precisely affords the OFWs with a recourse and assures them of immediate and sufficient payment of what is due to them. D. Estoppel does not confer jurisdiction over an immune entity. An entity immune from suit cannot be estopped from claiming such diplomatic immunity, since estoppel does not operate to confer jurisdiction to a tribunal that does none over a cause of action. 19-F. Doctrine of forum non-convenience. Doctrine of Forum Non-Convenience Requisites. According to the case of Bank of America NT and SA, Bank of America International Limited versus Court of Appeals, and Communication Materials and Design Inc. versus CA, under the international law principle of forum non-convenience. International law. Forum non-convenience. Forum non-convenience. International law. A Philippine court or agency may assume jurisdiction over the case if it chooses to do so, provided the following requisites concur: that the Philippine court is one to which the parties may conveniently resort, that the Philippine court is in a position to make an intelligent decision as to the law and the facts, and that the Philippine court has or is likely to have power to enforce its decision. Number 2, application of the doctrine of forum non-convenience to labor cases. Citing the above requisites enunciated in Bank of America, the Supreme Court rejected petitioners' invocation of this principle in Pacific Consultants International Asia Inc. versus Schoenfeld. Petitioners insisted on the application of this principle since the respondent is a Canadian citizen and was repatriated. In so rejecting, the Supreme Court cited the following reasons that do not warrant the application of the said principle. First, the Labor Code does not include forum non-convenience as a ground for the dismissal of the complaint. Second, the propriety of dismissing a case based on this principle requires a factual determination. Hence, it is properly considered as a defense. This principle, however, was applied in the case of the Manila Hotel Corporation and Manila Hotel International Limited versus NLRC. Private respondent Marcelo Santos was an overseas worker employed as a printer in a printing press in the Sultanate of Oman when he was directly hired by the Palace Hotel, Beijing, People's Republic of China, to work in his print shop. Later, he was terminated due to retrenchment occasioned by business reverses brought about by the political upheaval in China, referring to the Tiananmen Square incident which severely affected the hotel's operations. When the case was filed in 1990, petitioner Manila Hotel Corporation (MHC) was still a government-owned and controlled corporation duly organized and existing under the laws of the Philippines, while petitioner Manila Hotel International Company Limited was a corporation duly organized and existing under the laws of Hong Kong. MHC is an incorporator of MHICL, owning 50% of its capital stock by virtue of a management agreement with the Palace Hotel Wang Fu Company Limited. MHICL trained the personnel and staff of the said hotel in Beijing, China. In holding that the NLRC was a serious inconvenient forum, the Supreme Court noted that the main aspects of the case transpired in two foreign jurisdictions, and the case involves purely foreign elements. The only link that the Philippines has with the case is that private respondent Santos is a Filipino citizen. The Palace Hotel MHICL are foreign corporations. Consequently, not all cases involving Filipino citizens can be tried here. Respondent Carlos was hired directly by the Beijing Palace Hotel, a foreign employer, through correspondence sent to him while he was working at the Sultanate of Oman. He was hired without the intervention of the POEA or any authorized equivalent agency of the government. Hence, the NLRC is an inconvenient forum, given that all the incidents of the case, from the time of recruitment to employment to dismissal, occurred outside the Philippines. The inconvenience is compounded by the fact that the proper defendants, the Palace Hotel and the MHICL, are not nationals of the Philippines. Neither are they doing business in the Philippines. Likewise, the main witnesses, Mr. Schmidt, General Manager of the Palace Hotel, and Mr. Henk, Palace Hotel's manager, are not residents of the Philippines. Neither can intelligent decision be made as to law governing the employment contract as such was perfected in foreign soil This calls for the application of the principle of lex loci contractus. Contractus. Civil law. The law of the place where the contract was made. It must be noted that the employment contract was not perfected in the Philippines. Private respondent Santos signified his acceptance thereof by writing a letter while he was in the Sultanate of Oman. This letter was sent to the Palace Hotel in the People's Republic of China. Neither can the NLRC determine the facts surrounding the alleged illegal dismissal, as all acts complained of took place in Beijing, People's Republic of China. The NLRC was not in a position to determine whether the Tiananmen Square incident truly adversely affected operations of the Palace Hotel as to justify respondent employees in retrenchment. Even assuming that a proper decision could be reached by the NLRC, such would not have any binding effect against the employer, the Palace Hotel, which is a corporation incorporated under the laws of China and was not even served with summons. Jurisdiction over its person was not acquired. This is not to say that Philippine courts and agencies have no power to solve controversies involving foreign employers. Neither could it be said that the Supreme Court does not have power over an employment contract executed in a foreign country. If Respondent Santos were an overseas contract worker, a Philippine forum, specifically in the POEA, not the NLRC, would protect him. He is not, however, an overseas contract worker, a fact which he admits with conviction. Manila Hotel should be distinguished from Philippine National Bank versus Kabansag, where Respondent was hired by the Singapore branch of Petitioner Bank while she was a tourist in Singapore in 1998. Petitioner is a private banking corporation organized and existing under the laws of the Philippines, with principal offices at the PNB Financial Center, Rojas Boulevard, Manila. At that time, the Singapore branch office has two types of employees: expatriates, or the regular employees hired in Manila and assigned abroad, including Singapore branch offices, including Singapore, and B, locally directly hired in Singapore. She applied for and was hired as branch credit officer. After her 3-month probationary period, she was terminated. Subsequently, she filed a complaint before the labor arbiter. On appeal to the Supreme Court, one of the issues presented was whether or not the labor arbiter has jurisdiction over the instant controversy. The Supreme Court, in answering this issue in the affirmative, ruled that the labor arbiter has jurisdiction because the issue involves the termination of an OFW, overseas Filipino worker. While she may have been directly hired in Singapore by petitioner, however, respondent likewise applied for and secured an overseas employment certificate from the POEA, Overseas Employment Certificate. To the Philippine Embassy in Singapore. The certificate declared her a bona fide contract worker in Singapore. The certificate declared her a bona fide contract worker in Singapore. Thus, even assuming arguendo that she was considered as at the start of her employment as a direct hire, governed governed by and subject to the laws, common practices, and customs prevailing in Singapore. She subsequently became a contract worker or an OFW who was covered by Philippine labor laws and policies upon certification by the POEA. At the time her employment was illegally terminated, she already possessed the POEA employment certificate. Moreover, POEA employment certificate. Moreover, petitioner admits that it is a Philippine corporation doing business through a branch office in Singapore. Significantly, respondents' employment by its Singapore branch office had to be approved by the president of the bank whose principal offices were in Manila. This circumstance militates against petitioner's contention that respondent was locally hired and totally governed by and subject to the laws, common practices, and customs of Singapore, not of the Philippines. Instead, with more reason does this fact reinforce the presumption the respondent falls under the legal definition of migrant worker. Migrant worker. In this case, one deployed in Singapore. Hence, petitioner cannot escape the application of Philippine laws or the jurisdiction of the NLRC and the labor arbiter. Citing the said PNB ruling, the High Court in SIM versus NLRC noted a palpable error in the labor arbiter's disposition of the case, which was affirmed by the NLRC with regard to the issue in jurisdiction. It held that it was wrong for the labor arbiter to dismiss the case for lack of jurisdiction under its holding that labor relations system in the Philippines has no extraterritorial jurisdiction, that it is limited to the relationship between labor and capital within the Philippines, and that since complainant was hired and assigned in a foreign land, although by a Philippine corporation, it follows that the law that governs their relationship is the law of the place where the employment was executed and her place of work or assignment. The law follows that the law is the law of the place where the employment was executed and their place of work or assignment. The law of the place where employment was executed. The petitioner here in Corazon SIM was initially employed by Equitable PCI Bank, responded in 1990 as Italian remittance marketing consultant to its Frankfurt representative office. Eventually, she was promoted to the position of manager until September 1999 when she received a letter from Remigio David, a senior officer. The petitioner here is Corazon SIM, was initially employed by Equitable PCI Bank, responded in 1990 as Italian remittance marketing consultant. Its Frankfurt representative office. Eventually, he was promoted to the position of manager until September 1999 when she received a letter from Remigio David, senior officer, European head of PCI Bank, and managing director of PCIB Europe, informing her that she was being dismissed due to loss of trust and confidence based on alleged mismanagement and misappropriation for funds. According to the Supreme Court, the labor arbiter has jurisdiction not only on the basis of Article 224 of the Labor Code but under Section 10 of RA number 8042, as well as Section 62 of the Omnibus Rules and Regulations implementing RA number 8042. Under these provisions, it is clear that labor arbiters have original and exclusive jurisdiction over claims arising from employer-employee relations, including termination disputes involving all workers, among whom are OFWs. 19-G. Quasi-delict or tort cases. Labor arbiters. Number 1. Labor arbiters have no jurisdiction over quasi-delict or tort cases. The delineation between the jurisdiction of regular courts. No jurisdiction. Labor arbiters. Arbiters, no jurisdiction over quasi-delict or tort cases. The delineation between the jurisdiction of regular courts and labor courts over cases involving workers and their employers has always been a matter of dispute. It is up to the courts to lay the line after careful scrutiny of the factual milieu of each case. For instance, damages arising from quasi-delict or tort are often confused with damages that may be claimed under labor laws and labor agreements. Consequently, quasi-delict or tort damages are asserted in labor cases filed with the labor arbiters. As earlier emphasized, however, arise from employer-employee relationship, such as those emanating from quasi-delict or tort cases per Article 2176 of the Civil Code. That have no reasonable causal connection to any of the claims provided in the Labor Code, other labor statutes, or collective bargaining. The claims provided in the Labor Code or labor statutes or collective bargaining agreements. Thus, to sustain a claim liability under quasi-delict, the following requisites must concur: A. Damages suffered by the plaintiff. B. Fault of negligence of the defendant or some other person for whose acts he must respond. And C. The connection of cause and effect between the fault or negligence of the defendant and the damages incurred by the plaintiff. Indeed, jurisprudence has evolved the rule that claims for damages under Article 224, 217 of the Labor Code to be cognizable by the labor arbiter must have a reasonable causal connection with any of the claims provided for in the article. Only if there is such a connection with the other claims can a claim for damages be considered as arising from employer-employee relations. Number 2, the Tolosa case. The best example to cite on this legal point is the case of Evelyn Tolosa versus NLRC. Because of the death of her husband, Captain Virgilio Tolosa, a complaint for damages was lodged with the labor arbiter by the surviving wife, but the Supreme Court ruled that the labor arbiter has no jurisdiction over the case because it was established that the same was in the nature of an action based on a quasi-delict or tort. It being evident that the issue presented therein involved the alleged gross negligence of Captain Tolosa's co-employees, with whom Captain Tolosa have no employer-employee relationship. It therefore does not involve the adjudication of a labor dispute. Does not involve the adjudication. Does not involve the adjudication of labor dispute. But the recovery of damages based on a quasi-delict. Based on a quasi-delict. The jurisdiction of labor. Excuse. The jurisdiction of labor tribunals is limited to disputes arising from employer-employee relations. It is not the NLRC but the regular courts that have jurisdiction over which the cause of action proceeds from a different source of obligation, such as a tort. Since petitioner's claim for damages is predicated on a quasi-delict or tort that has no reasonable causal connection with any of the claims provided for in Article 224, other labor statutes or collective bargaining agreements, jurisdiction over the action lies with the regular courts, not with the NLRC or the labor arbiters. Endofield case, number 3. Another example of a case involving quasi-delict is the 2014 case of Endofield Textile Mills Inc. versus Indian El Salvador at Viento. Respondent worked for petitioner, which is engaged in the business of manufacturing thread for weaving, as civil engineer to maintain its facilities in Lampaquin, Marilao, Bulacan. As a result of his work, he was diagnosed with chronic sinusitis and thereafter with moderate, severe, and persistent allergic rhinitis. Distressed, respondent filed a complaint against petitioner with the labor arbiter for alleged illegal dismissal and for the payment of back wages, separation pay, actual damages, and attorney's fees. Subsequently, respondent filed another complaint with the regional trial court, alleging that he contracted such occupational disease by reason of the gross negligence of petitioner to provide him with a safe, healthy, and workable environment. The Supreme Court ruled that the RTC has jurisdiction over the subject matter. RTC is over the subject matter of the respondent's complaint, praying for moral damages, exemplary damages, compensatory damages, anchored on petitioner's alleged gross negligence, anchored on petitioner's failing to provide a safe and healthy working environment for a respondent. This is a case involving Pasay Deli. Respondent alleged that due to the continued and prolonged exposure to textile dust seriously inimical to his health, he suffered work-contracted disease, which is now irreversible and incurable and deprive him of job opportunities. Clearly, injury and damages were alleged suffered by respondent, an element of a quasi-delict. Secondly, the previous contract of employment with the petitioner and respondent cannot be used to counter the element of no pre-existing contractual relation, since petitioner's alleged gross negligence in maintaining a hazardous work environment cannot be considered a mere breach of such contract of employment, but falls squarely within the elements of quasi-delict under Article 2176 of the Civil Code, since the negligence is direct, substantive, and independent. Hence, when, as here, the cause of action is based on a quasi-delict or tort, which has no reasonable causal connection with any of the claims provided for in Article 224, jurisdiction over the action is with the regular courts. It also bears stressing that respondent is not praying for any relief under the Labor Code. He neither claims for reinstatement nor back wages or separation pay resulting from an illegal termination. The cause of action herein pertains to the consequence of petitioner's omission, which led to a work-related disease suffered by respondent, causing harm or damage to his person. Such cause of action is within the realm of civil law, and jurisdiction over the controversy belongs to the regular courts, where the resolution of the dispute requires expertise, not in labor management relations nor in wage structures and other terms and conditions of employment, but rather in the application of the general civil law. Such claim falls outside the area of competence of expertise ordinarily ascribed to the labor arbiter and the NLRC. 9-H. Criminal and civil actions arising from violations of the penal provisions of the Labor Code. Regular courts of jurisdiction. Regular courts of jurisdiction. The Labor Code has expressly conferred jurisdiction over criminal and civil cases arising from violations of the Labor Code upon the regular courts. The relevant provisions are as follows: Article 250, Article 258, Article 287, Article 303. Article 250, criminal and civil liabilities arising from violations of rights and conditions of membership provided for thereunder shall continue to be under the jurisdiction of ordinary courts. 258. While the jurisdiction to hear and decide the administrative and civil aspects of unfair labor practices vested upon the labor arbiters, the jurisdiction over the criminal aspect thereof is vested in the regular courts. Article 287. Although Article 287 does not mention expressly that the jurisdiction over the criminal violation of its provision is vested in the regular court. It, however, mentions the word court in paragraphs thereof, obviously referring to the regular court. Further, in the rules to implement the labor code as amended, it is provided that the regular courts shall have jurisdiction over any criminal action under this article, but subject to the required clearance from the DOLE on cases arising out of or related to a labor dispute. Article 303. Any provision of law to the contrary, notwithstanding any criminal offense punished in the labor code, shall be under the concurrent jurisdiction of the municipal or city courts at the courts of first instance. For more extensive discussion on this topic, please refer to the notes and comments on Article 303 titled Penalties, found in Volume 3 of this 3-volume series of the author on the Labor Code. 9-I. Constitutionality of labor contract stipulations. The constitutionality of stipulations in the CBA and other labor contracts. Most of the cases that found their way into the annals of labor law jurisprudence are concerned with the fundamental issue of validity of certain provisions or stipulations in employment contracts or collective agreements or similar documents. Never was the constitutionality issue ever raised over such stipulations. Thus, there has been no definitive ruling on this primordial issue of whether the resolution of the issue of constitutionality of labor contracts or any of their stipulations, which obviously arose from and reasonably causally connected with employer-employee relationship, falls under the ambit of jurisdiction of labor authorities like the labor arbiter, to the exclusion of the regular courts. Finally, in 2009, this issue was squarely addressed in the case of Halagueña versus Philippine Airlines INC. The Halagueña Doctrine. The Halagueña versus Philippine Airlines INC. Halagueña Doctrine. It was held that it is not the labor arbiter but the regular court which has jurisdiction to rule on the constitutionality of collective bargaining agreement. It's the regular court. Collective bargaining agreement. Petitioners here were employed as female flight attendants of respondent PAL on different dates prior to November 22, 1996. They were members of the Flight Attendants and Stewards Association of the Philippines, a labor organization certified as the sole and exclusive bargaining representative of the flight attendants, flight stewards, and pursers of PAL. On July 11, 2001, PAL and FASAP entered into a CBA incorporating the terms and conditions of their agreement for the years 2000 to 2005. Section 144 Part A thereof provides as follows. A. For the cabin attendants hired for November 22, 1996. 3. Compulsory retirement subject to the grooming standards provisions of this agreement. Compulsory retirement shall be 55 for females and 60 for males. PAL, ha? So, PAL. In a later letter dated July 22, 2003, petitioners and several female cabin crews manifested that the aforementioned CBA provisions on compulsory retirement is discriminatory and demanded for an equal treatment with their male counterparts. This demand was reiterated in a letter by petitioners' counsel addressed to PAL demanding the removal of gender discrimination provisions in the coming renegotiations of the PAL-FASAP CBA. On July 29, 2004, petitioners filed a special civil action for declaratory relief with prayer for the issuance of temporary restraining order and writ of preliminary injunction with the RTC of Makati City against PAL for the invalidity of said provision. In ruling that the RTC's jurisdiction, the Supreme Court made the following salient observations. First, petitioner's allegations and relief prayed for this in its petition clearly indicate that the issue raised is whether the CBA provision is unlawful and unconstitutional. Hence, The subject of litigation is incapable of pecuniary estimation, exclusively cognizable by the RTC, pursuant to Section 19(1) of Batas Pambansa Bilang 129, as amended, being an ordinary civil action, the same is beyond the jurisdiction of labor tribunals. The said issue cannot be resolved solely by applying the labor code. Rather, it requires the application of the Constitution, labor statutes, law on contracts, and the Convention on the Elimination of all forms of discrimination against women, and the power to apply and interpret the Constitution and CEDAW is within the jurisdiction of trial courts, Court of General Jurisdiction. Number 3. Not every dispute between an employer and employee involves matters that all labor arbiters in the NLRC can resolve in the exercise of their adjudicatory or quasi-judicial powers. The jurisdiction of labor arbiters in the NLRC under Article 224 is limited to disputes arising from an employer-employee relationship, which can only be resolved by reference to the labor code or the labor statutes or their CBA. CBA is collective bargaining agreement. Actions between employees and employer where the employer-employee relationship is merely incidental and the cause of action proceeds from a different source of obligation are within the exclusive jurisdiction of the regular courts. Here, the employer-employee relationship between the parties is merely incidental and the cause of action ultimately arose from different sources of obligation. Example, the Constitution, CEDAW. Convention on the Elimination of all forms of discrimination against women. Number 4, where the principal relief sought is to be resolved not by reference to the labor code or other labor relations statute or a CBA, but by the general civil law. The jurisdiction over the dispute belongs to the regular courts of justice and not to the labor arbiter at the NLRC. In such situations, resolution of the dispute requires expertise, not in labor management relations nor in wage structures and other terms and conditions of employment, but rather in the application of the general civil law. Clearly, such claims fall outside the area of competence of expertise ordinarily ascribed to labor arbiters in the NLRC, and the rationale for granting jurisdiction over such claims to these agencies disappears. Number 5. The regular courts are divested of jurisdiction over the case in which tribunal or forum shall determine the constitutionality or legality of the CBA provision. The grievance machinery and voluntary arbitrators do not have the power to determine and settle the issues at hand. They have no jurisdiction or competence to decide constitutional issues relative to the question compulsory retirement age. Their exercise of jurisdiction is futile as it is like vesting power to someone who cannot wield it. Although the CBA provides for a procedure for the adjustment of grievances, such referral to the grievance machinery and thereafter to voluntary arbitration would be inappropriate to the petitioners, because the union and the management have unanimously agreed the terms of the CBA in their interest is unified. Roman numeral 20. Period within which labor arbiters should decide cases. Period is mandatory. Period is mandatory. Article 224 in its first paragraph explicitly requires A. Except as otherwise provided under this code, the labor arbiters shall have original and exclusive jurisdiction to hear and decide within 30 calendar days after the submission of the case with the parties for decision without extension, even in the absence of stenographic notes, the following cases involving all workers, whether agricultural or non-agricultural. So it is in Article 224. To ensure speedy labor justice, the periods provided in the labor code within which decision or resolution of labor relations cases or matters should be rendered are mandatory. Decisions or resolutions of labor relations cases or matters for this purpose, a case or matter shall be deemed submitted for decision or resolution upon filing the last reading of memorandum required by the rules of the NLRC itself or the labor arbiter within 30 calendar days. Two to four. Upon expiration of the corresponding period, a certification stating why a decision or resolution has not been rendered within the said period shall be issued. Certification. And a copy. Upon expiration of the corresponding period, a certification stating why a decision or resolution has not been rendered within the said period shall be issued forthwith by the executive labor arbiter, and a copy thereof served upon the parties despite the expiration of the applicable mandatory period of these officials without prejudice to any liability which may have been incurred as a consequence thereof. See to it that the case or matter shall be decided or resolved without any further delay. Number 2. Rationale behind the policy. Public policy and sound practice demand that at the risk of occasional errors, judgment of courts should become final at some definite date fixed by law. The very purpose for which courts were instituted was to put an end to controversies, to fulfill this purpose, and to do so more speedily. Certain time limits, more or less arbitrary, have to be set up. Such periods are imposed to prevent needless delays and to ensure the orderly and speedy discharge of judicial business. To fulfill this purpose and to do so more speedily, certain time limits, more or less arbitrary, have to be set up. Such periods are imposed to prevent needless delays and to ensure the orderly and speedy discharge of judicial business. Strict compliance with such rules is both mandatory and imperative. Long periods for any acts to be done by the contending parties can be taken advantage of more by management than by labor. Most labor claims are decided in their favor, and management is generally the appellant. Delay in most instances gives the employers more opportunity not only to prepare even ingenious defenses, what with well-paid talented lawyers they can afford, but even to wear out the efforts and meager resources of the workers to the point that not infrequently the latter either give up or compromise for less than what is due. Part 2. Jurisdiction of the Commission, NLRC. Number 1. Kinds of jurisdiction. The NLRC exercises two kinds of jurisdiction: exclusive original jurisdiction, exclusive appellate jurisdiction. Exclusive original jurisdiction and exclusive appellate jurisdiction. Although Article 224 mentions in its paragraph only the appellate jurisdiction of the NLRC, it exercises, however, original jurisdiction over certain cases. And, contrary to the notion that its appellate jurisdiction is confined exclusively to all the cases decided by the labor arbiters, NLRC has appellate jurisdiction over other cases, such as the decisions rendered by DOLE regional directors in small money claims cases under Article 129 of the Labor Code. Exclusive original jurisdiction. The NLRC exercises exclusive original jurisdiction over the following cases: A. Petition for temporary restraining order, TRO, or injunction in two kinds of cases to it. In ordinary labor disputes, to enjoin or restrain any actual or threatened commission of any or all prohibited or unlawful acts, or to require the performance of a particular act in labor dispute which, if not restrained or performed forthwith, may cause grave or irreparable damage to any party. And in strikes or lockouts, under Article 279 of the Labor Code, certified cases which refer to labor disputes causing or likely to cause a strike or lockout in an industry indispensable to the national interest, certified to it by the DOLE Secretary for compulsory arbitration. Petition to annul or modify the order or resolution of labor arbiters, including those issued during execution proceedings under the new concept of extraordinary remedies. The TRO and injunction mentioned in letter A above may be availed of by an aggrieved party and subsequently issued by the NLRC, which the case is pending before the labor arbiter. In the same manner, a TRO and an injunction may also be availed of and issued by the NLRC as a preliminary relief under letter C above. As far as letter B above is concerned, an extensive discussion on this topic is found in the notes and comments on Article 278 infra under the following specific section 11 national interest cases, certification to the NLRC for compulsory arbitration. Part 3. Exclusive appellate jurisdiction. The NLRC exclusive appellate jurisdiction over the following: all cases decided by the labor arbiters, cases decided by the DOLE regional directors or hearing officers involving small money claims under Article 129 of the Labor Code, contempt cases decided by the labor arbiters. TRO or injunction in two kinds of cases to it: ordinary labor disputes, strikes or lockouts. Strikes or lockouts, NLRC exclusive appellate jurisdiction. All cases decided by the labor arbiter, NLRC. Cases decided. Part 3. Part 3. Jurisdiction of DOLE Regional Directors. Role of the DOLE Regional Directors. The DOLE has a total of 16 regional offices nationwide. Each one of them is headed by a regional director. The DOLE Regional Directors are the duly authorized representatives of the DOLE Secretary, referred to in Article 128 of the Labor Code, which grants to them both visitorial and enforcement powers. They are in charge of the administration and enforcement of labor standards within their respective territorial jurisdictions. Number 2, jurisdiction of the DOLE Regional Directors. The DOLE Regional Directors have original and exclusive jurisdiction over the following cases: visitorial inspection cases under Article 37, visitorial inspection and enforcement cases under Article 128, either routine or initiated through a complaint, visitorial cases under Article 289 involving examination of books of accounts of independent unions, local chapters, chartered locals, and workers' associations, occupational safety and health violations, small money claims, cases arising from labor standards violation in an amount not exceeding 5,000 and not accompanied with claim for reinstatement under Article 129, cases related to private recruitment and placement agencies for local employment such as applications for license or denial thereof, complaints for suspension or cancellation of license by reason of administrative offenses, complaints for illegal recruitment, and petition for closure of agency, cases submitted for voluntary arbitration, their capacities ex officio voluntary arbitrators under Department Order No. 83-07, Series of 2007, union registration related cases such as applications for union registration of independent unions, local chapters and workers associations, petitions for denial number 2 of application for registration of said unions, number 3, petitions for revocation or cancellation of registration of said unions, letter I, notice of merger, consolidation, affiliation, and change of name of said unions and or petition for denial thereof. Letter J, CBA related cases such as application for registration of single enterprise, CBAs or petition for deregistration thereof. Number 2, petition for denial of registration of single enterprise, CBAs or denial of petition for deregistration thereof. And K, request for SEBA certification when made in an unorganized establishment with only one legitimate union. Individual discussion of the above cases. Since some provisions covering the above cited cases falling under the jurisdiction of the DOLE Regional Directors are loosely scattered in the Labor Code and various labor issuances, the following simplified cross-references are made to the author's notes and comments on said provisions, if only to avoid wasteful duplication of commentary which may result in unnecessary confusion and obfuscation. Visitorial cases under Article 37. See comments on Article 37 found in Volume 1 of this 3-volume series by the author. Visitorial enforcement cases under Article 128. Visitorial cases under Article 128. Occupational safety and health violations. And so on and so forth. So part 4, let's have a break.